Most Kenyans do not like to talk about death and what happens after to the ones left behind. They prefer to ignore the topic and hope it goes away. As Haruki Murakami wrote in Kafka on the Shore, closing your eyes isn't going to change anything. Nothing's going to disappear just because you can't see what's going on. In fact, things will even be worse the next time you open your eyes. And that is exactly what usually happens. In this case, the people don't end up opening their eyes forever and chaos is left behind. Far, much worse. To make sure your loved ones have it easy after your natural life comes to an end, you ought to write a will. Here are a few tips to help you with that. Number 1, write a will. Kenya does not have a standard way in which a will can be written. Legally, a will can be written down by anyone above the age of 18, of sound mind, and under no influence or coercion. There has to be 2 adult witnesses or more who are required to sign it. It should capture details of the properties you own and whom you are bequeathing them to. Verbal wills can be presented, but they are usually easy to contest. By law, a verbal will can only be valid if the person making the will dies within 3 months of announcing the will. The most foolproof way to handle writing a will is to visit a lawyer who specializes in estate and property matters. Leave the document to the lawyer upon signing it. Number 2, children are not automatic inheritors. While children, regardless of age and gender, have a right to inherit, the law does not compel any parent to leave an inheritance for them. With that being said, disinherited children can petition the court to consider giving them a portion, which the court may decide to go against the deceased and award the child a part of the inheritance if they have a strong case. Also, despite some communities culturally disallowing daughters from inheriting property, the court can step in to guide against this form of discrimination. Number 3, next of kin does not automatically inherit. In most business transactions and investments in Kenya, individuals are required to name their next of kin. However, it does not mean that the money automatically passes to the person named as the next of kin if the account holder dies. If the person dies having made a valid will and passed the money to the next of kin, then the money is inherited legally. However, if there is no will that directs that the money be transferred to the next of kin, it is not automatically passed to them, and it is therefore distributed according to law. Indicating the next of kin is merely for the purposes of context in the event that the person transacting cannot be reached and has nothing to do with the inheritance. Number 4, joint accounts and co-owned properties. Properties owned jointly with others are not willed away upon the death of the maker of the will. When the co-owner dies, their share is transferred to the surviving partner. For married women who are the most vulnerable when their husband dies, the best way to prevent any latecomers showing up after the death of a husband is to insist on owning property jointly with their spouses. Number 5, grandchildren can always inherit. According to a ruling by Justice Musyoka in 2015, the only time grandchildren inherit directly from their parents is when the grandchildren's own parents are dead. The grandchildren step into the shoes of their parents and take directly the share that ought to have gone to the said parents.